All right, we are about to get started. Let me just wait for a few more people to jump on since it's so early. Um, okay. All right. Okay. What is the time? It looks like it is 2 minutes after 12. We're going to go ahead and get started. And as people come on, we'll have to just keep moving, because I want to respect everybody's time and because there is a replay for this webinar that will be available to everyone um, who registered. So you are in the webinar with the title that you can all hopefully see on your screens, Beyond the Kitchen Table, talking to parents about planning. And we're throwing in some things about taxes because that is the quintessential subject everybody needs to know about. Um, All right, a few housekeeping things before I get started and properly introduce myself. There should be on your screen, there should be a chat feature where you can submit or you can see us if we want to share something with you. There's also a Q&A, and if you can put your questions, if you have questions, if you would put those in the Q&A, then when we answer them, everyone can see those questions and the answer. Um, that way, other people can benefit from the question and the answer. We are going to go through quite a bit of material. I'm trying to keep this at 30 minutes. So I want you to ask your questions in the Q&A, but I probably won't get to your questions until the end. And if I don't get to your questions, we will be able to have you call me directly. Lauren is going to place in the chat a link to contact us for it's a calendar link, so you can schedule time to talk to me. 15 minutes, I think, is what we have, but you're not limited to the
Yes.
15 minutes. And also, you're going to hear some things about where you can find additional material, so we'll give you links there as well. But without further ado, let me properly introduce myself. My name is Michelle Gessner. I am a certified financial planner and the owner and founder of Gessner Wealth Strategies right here in Houston, not too far from the Galleria area, away from the Galleria craziness, but close enough to where everybody knows where we are. We are taking care of all things financial planning as well as investment advice. We are fiduciary only on the investment advice, so no commissions are taken. That way it eliminates bias and we can be giving advice in your best interest. All things financial planning includes tax planning, and we have an emphasis on that, estate planning, asset protection, risk mitigation, all of that. So anyway, that's what we do. We help retirees, we help pre-retirees, we help younger folks as well. In fact, there's a lot more complexity when you're young than people realize. So, we have clients in that area as well. All right, so today, and let me just tell you why we're giving this webinar. I actually had a client ask for us to record something like this, meant for understanding how to help parents with estate planning. So the idea was born out of that client's recommendation. And so the material today, we're going to be talking about the things you should look at regarding smart estate planning for your aging parents. If you think this is a valuable webinar, send the replay to whomever you think would benefit. But just because I am assuming the audience is a younger person or an adult child of aging parents, doesn't mean you can't send this webinar to your aging parent, because I think there's information that's really important for everyone to know. And then of course we're gonna cover tax planning 101. And when I say tax planning 101, I'm not talking about tax preparation. So your tax preparation, everyone's familiar with that. Either you do it yourself or you hire someone to do it. What I'm talking about is forward-looking tax planning, which typically CPAs do not touch. They're looking at what happened last year. Let's get you the deductions you're eligible for, et cetera. What I'm talking about is how do we look at mitigating, lowering your tax burden in the future before the tax year is even over with. All right, so here is all of our disclaimer language, which we have to put out as a registered investment advisory firm. I just have to remind people I am not giving legal advice. I'm not giving specific investment advice. This is for education only. If you need tax advice, legal advice, etc., please consult those experts. All right, without further ado, so let's get started. The topics that should be addressed with your aging parents. First off, how are your parents' investment accounts titled? Now, this is super important because what some people don't realize is it does not matter what the estate planning documents say, what their will says, what their trust says, if they have account titling that doesn't agree with those documents, because the titling of the accounts prevails over those documents. So if you've got a title that says one thing and a document that says another, the title wins, it prevails. And I'm going to give you an example with a little very rudimentary stick figure drawing in just a minute to help you understand why this matters and how a parent can accidentally disinherit their own children. Now, I like to make the joke, hey, if they want to disinherit you intentionally, that's one thing, but they don't necessarily want to disinherit you accidentally. So that's what we want to prevent. And I'll show you what I'm talking about in just a few minutes. The ancillary documents. So these are the documents that go with the trust or the will that are also very important to have, and they get often overlooked. So what I'm talking about is the financial power of attorney, the HIPAA release, and the medical power of attorney, as well as the advance directive. That's not listed here, but that's also important. So a financial power of attorney is the document that allows someone to sign on their behalf for financial accounts. So make withdrawals from an account that they're not necessarily on, but they're a power of attorney, or attorney in fact, I should say, so they can make withdrawals from an account. That's what that document does. The HIPAA release, that's so that the doctor can share information with someone who is not necessarily the patient. So you may not realize, or maybe you do, once someone turns 18, doctors don't necessarily talk to parents. They're not allowed to, because that person is considered no longer a minor, and now they need a HIPAA release. So I recommend that people get a HIPAA release as young as 18, so that if someone is incapacitated, maybe they're unconscious, maybe they're in a coma, the doctor can't talk to the parent about medical things going on without that important document. And then the medical power of attorney, that document is for making medical decisions when that person can't make them for themselves for whatever reason. The second bullet point there, avoid the dreaded guardianship route. What I mean by that, nobody wants to have to set up a guardianship. That is a horrible pathway, but that's the pathway you've chosen if none of these documents are in place and something goes wrong. And I'll give you an example. Let's say your parent ends up with a diagnosis of dementia, and it is necessary to get them care. They can't care for themselves. They're exhibiting all the classic dementia behaviors, and they need medical attention, they need medical care. So who's paying for that? If none of these documents were set up, well, the will or the trust doesn't matter because they haven't passed away. So even though you might be a beneficiary, they're still alive. So those documents are not in play here. And if they don't have a financial power of attorney or a medical power of attorney, you would have to go to the court and set up a guardianship. And doing that requires legal fees. $10,000 is not uncommon. Medical fees, because you have to get that person declared incapacitated. So you've got to spend medical fees for evaluations. You'll have to set up a surety bond. There's a fee there. And you're literally going to the court and asking for their permission to take over your parents' financial accounts. And so they're going to require, the court is going to require annual reports that document every penny spent. So this is going to be a bit of a burden, to say the least. It'll be public, so there's no privacy. And you'll have to do things like get the court's permission every time you need to make a decision, such as maybe selling their property, moving your parent to a new facility. The court has to stay involved. So this is not something anyone would wish for, but that's the route that happens when these documents are not taken seriously and put in place as a matter of course. And then tax planning issues. So this is preserving as much money as possible because you've done the important tax planning, or they've done the important tax planning. And this is especially important to review with aging parents. There's such a thing called the widow's penalty. Now, it's a slang term. It's not a real, technical term. But what is the widow's penalty if you hear that thrown around? What that's talking about is two people, let's say you have a married couple, husband and wife, maybe your parents. One of those parents will pass away first. Typically, people don't pass away at the exact same time. So the surviving spouse is now no longer married. And the year after the death, that surviving spouse will have to file as a single person. And what does that mean? That means automatically they're going to a higher tax bracket, typically, because the single tax brackets are much narrower than the married filing jointly tax brackets. Also, what happens is the standard deduction is half the size of the standard deduction for a married person. The thresholds for Medicare penalties, what they like to call them IRMA, surcharges, I like to call them penalties. So Medicare costs more because that threshold is now a single threshold, which is lower. And Social Security tax thresholds are lower for single people. So those are just some examples of how the surviving spouse can automatically be in a higher tax bracket. And coupled with that, their Social Security benefits are lower because you might have had two checks coming in. Well, now there's only one check. It's the higher of the two, but still only one check. So less money coming in and narrower tax brackets. That's the widow's penalty. So what do you do about it? Well, you do some tax planning before anything happens. And then inherited IRAs, the rules have changed. And I'm going to talk about that on the next couple of slides as well. So just a sneak peek about that. After the Secure Act was passed in 2020, and then again, there was an amendment or 2.0, they call it, in 2022, went into effect 2023. Those changed how inherited IRA accounts are taxed and how they're handled. So I'm going to go into that so you can understand what is at play here so you can make smart decisions for yourselves. So let's tackle that topic first, the IRA, the inherited IRA. So what the Secure Act of 2020 and 2023 did, it eliminated the stretch IRA for non-spousal beneficiaries. So that's a mouthful. What does that mean? If you're not a husband or a wife inheriting someone's IRA that you were married to, you're a non-spousal beneficiary. So a child, for example, an adult child inheriting mom or dad's IRA, that's what this pertains to. So what this means is you can no longer, the old rules were you could take these little tiny required minimum distributions out over the course of your lifetime, maybe just a little bit here and there or every year. And so it wasn't a big tax event. But now they've eliminated that for non-spousal beneficiaries, not for spousal, that stays the same. But I'm going to give an example. So if you're an adult child that is inheriting, let's just say $500,000 of tax deferred money, otherwise known as an IRA, in 10 years, according to the Secure Act, there are some things that happen. Well, first off, let's assume that you keep that money invested. And in 10 years, it becomes $1 million, which is not a stretch. If it's invested properly, it would likely double. So now it's $1 million. You haven't taken any withdrawals. You weren't required to take any withdrawals because that's the new rules. And it's been invested. Okay, well, now in the 10th year, you have to empty the entire account. That's what the Secure Act says. Now, you can take withdrawals up until then if you want to. It is required to take withdrawals called RMDs, which is the second bullet there, if the decedent, your parent, was already starting taking RMDs, you have to continue that. But if they hadn't, maybe they hadn't reached RMD age, and so you don't have to. But so the example in this case, let's just say you didn't take any withdrawals because they weren't taking RMDs. And so you're not going to continue to do that. You don't have to. Now, in 10 years, according to the Secure Act, that entire account must be emptied to a regular account, which instantly causes a tax event where all of that money, that withdrawal, lands on your tax return and triggers a cascade of events. Maybe it puts you in the much higher tax bracket. Well, heck, if it's $1 million, it's definitely going to do that. And so you not only have the highest tax bracket, but now you've triggered other things like net investment income tax, and you've triggered the Medicare tax. So there's all kinds of things that happen. So let's just call it 40%. The best case scenario is you were taking little withdrawals throughout the 10 years. Let's just say a tenth of the amount. So $50,000 a year lands on your tax return. And does that put you in a higher tax bracket? Likely, yes. And at the end, you still have, if you had invested at say 8%, you still have $355,000 that lands on your tax return at the end of the 10th year. So that's the best case scenario. None of this is what people want. They used to be able to stretch these things out and not have to take these large withdrawals. But that's a thing of the past for non-spousal beneficiaries, and that can be a tax bomb. So yes, there are things you can do, but only for the parent. There's not a lot that you can do with your parents' money except educate them and let them become aware, and so they can do the proper planning, and we can help with that. Now, remember I said there was going to be a rudimentary stick figure drawing? Well, here it is. And this is to illustrate that accidentally disinheriting your adult child kind of phenomenon. So what you got here, and I'll use my mouse, this JWROS, that is actually a very common way to title, that custodians title a joint account. And what it stands for is joint with right of survivorship. Now, joint with right of survivorship, what that means is that you have an account owned by two people and jointly they own it roughly equal shares, or definitely equal shares. And the right of survivorship means that upon the death of the first person, the second or surviving spouse or surviving person, you don't have to be married, the surviving person automatically becomes the owner of the account and enjoys all the features of being the owner of the account. And it does not matter what the will or the trust says. This prevails over anything else. And so no, you don't have to go through probate or anything like that. So it's nice in that circumstance. But here's an example where that may not be so nice. So here's my example. Let's say you have a husband, H for husband, wife, W for wife. Husband and wife are equal owners of this joint with right of survivorship account. And they have named their children as beneficiaries on the account at the second of them to pass. Okay, so they both own equal amounts in this account. Now let's just say in our example, the wife passes away first. So that's the big X. Wife passes away. It might be your parent, your mother. And so now your father owns the account. He doesn't have to go through probate. The account is his. And you two, the siblings, two people, are the beneficiaries. All right, all is well. But now he gets remarried with W2, in this case, wife number 2. He gets remarried and he doesn't understand all of this. And he retitles the same account to joint with right of survivorship, where now she and they both own this account in the same manner. Now, let's say in this circumstance that he passes away first. So now wife number 2 is the owner of the account, and yes, she enjoys full benefits of the ownership, in specifically the ability to change the beneficiaries. And so she does. She changes the beneficiaries to her own children. So you and your sibling are now cut out of the picture. And this is not, let's just say, this is not what your father intended. He just didn't know. He thought that his will or his trust took care of that. It does not. The account titling prevails over the will and the trust. And that is how you accidentally disinherit your own children. It happens, but it only happens if you don't understand the rules. Some other problems I want to talk about. So this is my poor planning slide. So we have often adult children will put themselves on, or the parent asks for the adult child to be a joint owner on their account, so that the adult child has access to their money when there's a problem, and they can help them as they age. That's what we call a convenience account. It's a joint account, maybe a joint bank account, a joint investment account. Your name is on there, so you have equal ownership. Great. What's the problem, you might ask? Well, the problem is that you your legal problems become your parents' legal problems, if you have any, and maybe you don't. But let's say something happens where you get into an at-fault car accident and you are sued. And you could come up with a number of different legal lawsuits and why you got sued, but you got sued and you're at fault. It's your liability. The plaintiffs are going to go after your assets. And your asset would include your parents' account because your name's on it. So why expose your parents' money to your own potential liability? And nobody ever thinks anything's going to happen, but you never know. So it's not the ideal way to handle having access to your parents' money when there's a better way. And what's the better way? It's that financial power of attorney that I was talking about. Another type of power of attorney that's also financial is a springing power of attorney. And the difference between a durable power of attorney and a springing power of attorney, the difference is this. The springing power of attorney only goes into effect or springs to action at the principal's incapacity. In other words, they have to become disabled. Your parent has to become disabled or rendered or labeled by a medical opinion that they are incapacitated before you, the attorney in fact, the power of attorney, can have access to their account. So that's what springing power of attorney, as opposed to durable power of attorney, which doesn't depend on any kind of disability to actually occur. It goes into effect immediately. Well, what's the problem with the springing power of attorney, you might ask? Here's the problem. The problem is people don't realize how burdensome they can be. Now, it might be the right instrument in some circumstances. If there's not a lot of trust, or your parent just prefers it that way, that's fine. But I want you to understand what you're signing up for, what they're signing up for. You would have to, the person who is the attorney in fact on this POA, would have to get two medical opinions that the parent is, or whoever it is incapacitated. So let's say you have a parent with dementia, and the dementia is getting worse, but maybe it's not yet there, and you're thinking, oh goodness, I've got to act. They're not paying their bills, they're doing things, they're forgetful. You have to take them to two doctors. Now, it may be hard to even take them to one doctor. They have to agree to have you take them. And people understand, if you've ever had any interaction with someone who's got dementia, one of the hallmarks of dementia is a personality change. And that can be aggression, more aggression. So it may not be easy to take them to even one doctor, much less two. And if their dementia is sporadic, maybe the day that you took them to the doctor is the day that they were coherent and everything's fine. So it depends. This whole thing depends on cooperation. So that's the problem of a springing POA. Whereas the regular durable power of attorney goes into effect immediately. And yes, it requires trust, so it is not right for everyone. The durable power of attorney that I've been talking about has to be filed ahead of time with most custodians, like Schwab, Fidelity, whoever your custodian is. They like to get those ahead of time, not when the situation is coming. And the reason they like to get those filed with them ahead of time is because they don't want to accept the liability that perhaps that power of attorney could have been written fraudulently. So they like for you and your parent, or whoever's the principal, to sign their paperwork. And so for our clients, we get that done immediately. It's on file. So that way, if something happens, there's no delay, there's no problem. Now, A custodian can reject. That doesn't mean you can't bypass that. But you'd have to probably hire a lawyer, and there's going to be legal fees and, of course, delays. So why deal with that when you can just have it filed ahead of time? Now, all powers of attorney end upon death. Those are only instruments for while that person is alive, just so you know. And I'm going to show you a slide on the next slide. We'll give it a more visual representation so you can see how they differ. The question here is, do you have a revocable living trust in place at death that would go into effect for death? If not, then if it's just a will, well, then there is a delay for probate. Now, the state of Texas does not have a convoluted and horrible probate process, unlike some states which do. New York, California, Florida, you'll hear stories about how probate is just a mess over there and requires a lot of delay, and a lot of people like to have trusts when they there. You don't have to have a trust in Texas, but just understand that trust does not require probate and a will does. With a trust, a revocable living trust, because there's all kinds of trusts, but we're talking about the RLT, the successor trustee steps in automatically at the death of the first trustee. So to put it in regular language, your parent, let's just say, is the trustee of their own trust, which is very common for a revocable living trust, and you are named as the successor trustee. Well, you would step in automatically at death. There's no probate. If you're talking about incapacitation, disability, they didn't die, that there's just dementia or something like that, there are provisions in trust that deal with that. And yes, there's still a delay because maybe the provision still requires medical opinions and all of that, although some trusts don't require that. But they're more readily accepted by custodians than these POAs that we're talking about. Now, you can, if you want to have access together, you can designate in the revocable living trust co-trustees that are independent, which means that one doesn't have to get the other one to agree, and one you can sign independent of the other, and then it's a very seamless process. Now, as a co-trustee, you still have to act for the creator's benefit. You can't just do whatever you want. There's sort of a fiduciary responsibility there, of course. But the important part about having a revocable living trust with independent co-trustees is your creditors cannot get to the trust assets like a convenience account that I was talking about, a joint account. So that's why it's better to do it that way or have the durable power of attorney. This is the diagram I was referring to that helps you see visually the life of the different instruments. So this yellow, I didn't really talk about that one. That's a non-durable power of attorney. It goes into effect immediately and ends at incapacity. I don't see those too often. The springing power of attorney is the green. That only goes into effect upon proof of incapacity typically by two doctors, and it ends upon death, like all powers of attorney. The next one is the durable power of attorney. That one goes into effect immediately upon execution. It does not change upon incapacity because it was in effect immediately, and it only ends upon death, like all powers of attorney. The revocable living trust is the orange, and that one goes into effect immediately. It has provisions typically for incapacity. The provisions could be a disability panel that doesn't include a doctor's opinion, or it could be one or two doctors' opinion. It's written however you want. And so there is no need for a power of attorney for assets that are titled to the trust. It does not end at death. It continues, and it only ends upon trust termination. So that's a nice document to have. And again, doesn't need probate. All right, we're going to segue into the other part of this discussion, which is taxes. So remember I said tax planning 101. First question to ask yourself is, where do you think tax rates are going? And where do you think experts think tax rates are going? And I can tell you, the research shows that experts' opinions, they believe that taxes are going up. We've got lots of debt, high deficit, and it's actually gotten worse over the years. I have a slide, I don't have it handy for this presentation, that actually shows you what the federal deficit has been and where it is today. So yes, we believe that tax rates have no place to go but up. And here's a history of the highest tax rates we've had in our country all the way back to 1913. So what you're looking at are the highest marginal tax bracket for individuals. And you can see here's where we are today. We're in a historically low tax rate environment today. It's 37%, which sounds like a lot, and nobody likes paying that, of course, but it's been higher. You can see in the 70s, it was at 70%. And post World War II, it was really high at over 90%. And so people believe that, yeah, history has a way of repeating itself. It's been done before, it could happen again. So, why do I show you this slide? It's to reiterate that you can do some tax planning now, and maybe that includes doing some Roth conversions or paying taxes now versus later, which is an option because we're in a historically low tax rate environment. So just a quick primer on how money is taxed, and really all money fits into one of three buckets, right? So there's the regular taxable bucket. That would be things that are not IRAs, things that are not 401ks. This is just ordinary money that could be in a savings account, a checking account, regular investment accounts, whether there's individual or joint accounts. Now, we are not talking about how they are invested. We're just talking about how they're titled. What's the benefit of such an account and what's the disadvantage? Well, the benefit is that these accounts have no rules about access. You can access them at any time, at any age. You can put as much money as you want in these accounts. You can take out withdrawals whenever you want. And so they're very liquid. So what's the disadvantage to a regular taxable account? Well, the disadvantage is they produce taxable events for you, whether or not you withdraw money. So every year you're going to get a 1099 INT or DIV if you, INT stands for interest, DIV stands for dividends. So as you make money on these accounts, they count as taxable income in your tax return, on your tax return, whether or not you withdrew. If you sell something and you have a capital gain, that's a taxable event. So that is how those work. We don't like that very much, but we also like the liquidity. So those accounts are not terrible, but there's a better choice here, and you're probably guessing which one it is. Well, the tax deferred bucket, let's cover that one next. That's your 401k, your 403b. These are the tax deferred accounts, IRAs, pensions. That's money that goes in pre-tax, never been taxed. It grows tax deferred, and it comes out taxable. Comes out meaning when you withdraw. So if you don't withdraw anything, you're not being taxed. And so that's people like that. They like the fact that they can contribute to an employer account or an IRA, and they're not being taxed on that money. They get the deduction today. Everybody loves a deduction. The problem is that you're basically delaying the inevitable. And when you delay the inevitable, there's always a price. And here's the price. All that growth that you don't even have yet will be taxed at the rates that are in place when you take it out. So we just talked about taxes are likely to go up. And so all that growth you don't even have yet. So let's just say your $10,000 becomes $100,000. Well, the government gets a piece of the 100,000, including all that growth. So that's what we don't like about this bucket is it's really hard to do planning because your $2 million IRA, let's just say you have one or 401k, is not $2 million. It's another sum of money because some of that goes to the IRS. And it comes with all kinds of access rules. You have to be 59 and a half to take withdrawals or you get slapped with a 10% penalty. When you turn 73 or 75, depending on when you're born, you have to take those required minimum distributions, which forces a tax event when you're in retirement, when you don't want to have a tax event. So those are the disadvantages. And then the tax advantage bucket, I like to say the tax-free bucket, that's anything Roth. And it's underutilized in our country. They're not, these accounts, I don't remember when they were first available, but not been available forever. I think it was like in the 90s. But Roth IRAs, Roth 401ks, Roth 403bs, anything with the name Roth, what is that? That is after tax money that goes in and then it grows completely tax free if you leave it alone and comes out tax free. Now, I say if you leave it alone because these have rules too of access. You have to be a certain age to take out the growth, but you don't have to be any age to take out the principal. So those are the principal's liquid at any time. And the best part about these accounts is all the growth that you don't even have yet is all yours. And when you take withdrawals in retirement, they do not trigger all these nasty things. They don't land on your tax return. There's no tax event. They don't trigger Social Security taxation or Medicare surcharges, otherwise known as IRMA. So it's really, really important to try to build some Roth money while you can. So I highly recommend Roth accounts, especially for young people. Real quick, the rules about your tax deferred accounts, your IRAs, as I said, you have these required minimum distributions. You'll hear people talk about them as RMDs. Now you have to take your RMD, hence the word required in the name. You have to take it out when you become of RMD age, which is 73 or 75, depending on when you were born. But you can take more. You just have to at least take that. And so what happens when you take that withdrawal? Of course, it lands on your tax return and it causes a tax event. If you were a great saver and you have a really nice pile of money in this tax deferred IRA, RMDs can become a tax problem, right? Because now you've got this large RMD. It could be a six-figure RMD, very common. And now you thought you were going to be in a lower tax bracket in retirement. You're not because you have a six-figure RMD that lands on your tax return. And if you don't take it out, that results in a 25% tax penalty on top of the ordinary income tax that you would also be paying. So you could be looking at double that. So what's the answer to handling these accounts? Well, tax planning. You can do some forecasting with your financial planner and figure out how to manage those, how to reduce those, how to get that money in the right bucket. Less money in tax deferred, more money in tax advantaged. And I'm just showing you on this slide what the percentage is when you turn 73. Now, for people who are born in 1960 or later, the age is 75. It used to be earlier, but the Secure Act changed that. But for your parents, it's likely 73. So 3.65% of the balance on December 31st of all IRAs added together, or 401ks, all of that, that's the amount that has to be withdrawn. And then it goes up from there. It goes up every year as that person ages. I just have some age points listed. And so, yeah, this can become a tax issue. And of course, we already talked about what happens if it never gets turned into Roth money and then it gets inherited by a non-spousal beneficiary. It becomes a tax issue for that person. Obviously, I'm a big fan of Roth accounts. They provide a hedge against future tax rate changes because you're getting taxed at today's rates, and then all the growth and everything else is yours, and there is no tax event later. So you're paying at today's rates, and you don't have to worry about a tax event when you're in the sensitive retirement years. Um, Income tax is not due on these earnings. So that's a big important point I want to just make sure I emphasize. And they don't trigger this nasty Social Security tax or Medicare surcharges. And what can happen, and I see this when we do these analyses with and without Roth, you can extend the life of someone's retirement money by years, depending on how much Roth money they have. All right, so we are reaching the end, but I want to just give you a tip here. I've recorded some podcast episodes, and those are available. And I think Lauren is going to put this link that you see in the chat box. Yeah,
I just did. Yep.
Yeah, so if you want to hear more about taxes, and because this presentation could go into a whole lot more, but we just didn't have time for that. You can check out some of these episodes that you might want to see. And I don't know, Lauren, if you can do a quick copy and paste into the chat all of these episode numbers, but you can browse that link that Lauren gave you and see what what topics are of interest to you. But here are the tax topics.
And
All
then,
right.
Michelle, I've actually got a couple of questions. If we've got a few more times, I know we're a little bit over on our time, but
Sure.
would you be okay answering some stuff?
Absolutely. Yeah.
All right, perfect. So, let's see. How much do the ancillary documents cost? So, the estate planning documents you talked about at the beginning, how much did those cost?
So if you're just talking about standalone ancillary documents like the HIPAA release and the powers of attorney, both medical and financial, maybe the advance directive, those are what I'm calling ancillary documents. Maybe you don't need or want the other documents for whatever reason. If that's what you're talking about, I think lawyers charge about $500 for all of that. They'll charge you by the document. It's probably better to get those along with the whole package, the will or the trust. If you get a will package for a couple with all of those ancillary documents, those can cost about 1,800 and up, depending on the lawyer. Um, a trust can cost anywhere between 2,500 and I've seen a trust, usually 2,500 is on the low side. A trust package with everything is usually more like $5,000, $6,000. Our clients, however, enjoy a much lower cost because we have access to a back office provider that will allow you to get those ancillary documents. If you just want them standalone, it costs $125 for our clients, and for a will package or a trust package, that's just part of our financial planning fees, and we don't pass that on for those clients. I hope that answers the question.
Yeah, hopefully. I guess we'll know. All right, I've got a couple more questions if you've got us. Okay. Next question is, can I do a Roth conversion once I inherit my parents' IRA?
No, you cannot. I really appreciate that question. So I didn't talk a lot about Roth conversions, but that is a tax planning technique, is to get that tax deferred IRA that may belong to your aging parent converted to Roth money. Maybe your aging parent is in a very low tax bracket. And so it might be a wise decision to get that converted, because once your parent passes and it becomes an inherited IRA, you cannot convert that to Roth. It's just disallowed. It can only be converted to Roth by the owner of the account. So clearly they have to be alive. Um, can't do it after it's already an inherited IRA.
So planning for their parents is super important right now.
Oh yeah, no, I really encourage people to work together. I know it can be tricky to bring up these kinds of topics with parents. That's why I think that it's helpful if you want to pass this webinar replay onto your parents, and just so they can get educated and then they can decide how they want to handle things.
Mhm.
Everybody's different, but it needs to be at least considered and understood so that a
Mhm.
decision can be made that's right for your family.
Yeah. Okay. And then one more question. What do you charge?
What do we charge? Well, if you decide that you want to at least learn more about us, that's where we start. That link that you see on the slide is a link to my calendar where we can talk for 15 minutes or so. We don't sit there and time you. Just so we can talk about whether, I mean, maybe you have a question, maybe you don't know if you want help, or maybe we're not even a good fit, but we can at least perhaps have a conversation. If we feel together that, hey, we might be able to help you, you might want to talk more to us, you can come into our office, and still we don't charge because we want to get to know each other, and there's no charge for that meeting. But if you do decide to become a client, there is an investment management fee on investments that we manage for you. And then there is a separate financial planning fee if you want a financial plan. And financial plan is everything we've been talking about and more. And like I said earlier, it includes the estate planning documents for those people who qualify.
Mhm.
So it's a pretty good deal. But there are people who don't need or want financial planning; they only want the investment management, and so that fee is separate. But yeah, I think it starts with just talking first, and of course, the fees are going to depend on the complexity and the size of the account and all of that. So better for us to talk and then we can zero in on exactly what your fee would be. Oh, and I see here that I didn't mention, we have for attendees of this webinar, if you would like our trustees basics, trustee basics is a nice write-up on what does a trustee do for a trust. It's written in plain English, or the trustee checklist. I can make sure that that's sent to you. Or if you want to be placed on our monthly newsletter, which you can always unsubscribe from, it'll come into your email box. Put your contact information in the Q&A section and we will make sure you get those items. Any other questions that you see, Lauren?
No, that is it.
Okay, well, if you are watching this as a replay or you don't think of your question until after we're finished here, reach out to us. If you don't have this link, you can always just reach us by going to our website, GessnerWealthStrategies.com, and our contact information is there. And you can see it's also here on the slide. I hope this was helpful. Please feel free to pass this on to people that you think would benefit, and I appreciate your attendance today.
Bye-bye.